I'd like to start with a famous proclamation of Lord Acton. Power tends to corrupt, and absolute power corrupts absolutely. The ANC's counter-deployment policy unashamedly exposes the party's ambitions to seize total control over every aspect of the state. My learned friend Mr. Katz has delineated in detail what paragraph 10 of the policy aims to achieve. It lists all of the different aspects of the state in which it wants to seize power over. But the state is not enough for the party. Just like for Bond villains, the world is not enough. Its lust for power extends to the media, businesses in all major sectors, and even religious, sporting, and cultural bodies. It wants to wrap its tentacles around everything in South African life. And to avoid ever being held accountable, the minutes of the Deployment Committee even sketch out a mechanism to undermine the independence of the judiciary. The minutes describe the current process of appointing judges as incestuous, since it provides for a system that has the judiciary having too much power in determining the leadership. And we see this echoed in the arguments raised by the respondents, in that they say this court shouldn't have power over this case. It shouldn't be able to decide. The findings of the State Capture Commission make it abundantly clear that it would be unconstitutional for the government to act on the instructions of the ANC Deployment Committee. The report states the following: within the current constitutional and statutory framework, it is unlawful and unconstitutional for a president of this country and any minister, deputy minister, or director general, or other government official, including those in parastatals, to take into account recommendations of the ANC Deployment Committee or any similar committee of any other political party in deciding who should be appointed to a position in the public service in organs of state or parastatals. Now, in the government's heads of argument at section 6, page 129 at paragraph 131, it stated that consideration of the Deployment Committee's recommendations or resolutions would be a contravention of the memorandum of incorporation of the PMFA of the minister. So they give an example of when it would be unlawful for the minister to act on these recommendations. The ANC itself, at section 6, page 102 in its heads of arguments at paragraph 30, says the party policy recognizes the limits of its reach, and it cannot encourage government to breach its duties. So it's accepted that there is a duty on government not to listen to the recommendations of the ANC's cadre deployment committee. And the ANC itself accepts that it cannot encourage government to breach its duties. But that is exactly what the aim of the policy is. The aim of the policy is to whisper in government's ear and say, pick this person. And when you come to ANC meetings and you're wearing your ANC hat and you didn't listen to our recommendations, there will be consequences. Both the government and the ANC are parties to an unlawful practice. The government is akin to a thief for hire, and the ANC is akin to the criminal network ordering the theft. And unfortunately, it is the South African public that has been stolen from. The amicus supports the relief sought by the applicants and will focus on 5 issues in the submission. Firstly, to talk about the devastating effects on the economy, with the poorest of the poor feeling those effects most dramatically. Secondly, that the policy violates the rule of law. Third, that it violates the value of non-racialism, which is in section 1 of our constitution and seen as a foundational value. Fourth, that it amounts to unfair discrimination on the grounds of race, belief, and conscience. And fifth, that the attempts to control the press undermines press freedom. Now, my little friend Mr. Katz is right to say that this court must look at what the legal obligations are. But it would be remiss of me not to mention the economic devastation, to look at the real-world effects of this policy. Barbara Hogan's testimony at the Commission describes the vast asset bases and strategic importance of Eskom, Transnet, and SAA. She says if Transnet does not work, none of us work. Eskom is responsible for 97% of the electricity generation, and we have all experienced the consequences of its failure with widespread blackouts. She underlines the need to have the best of the best on the boards of the SOEs. So where do we find ourselves? Last year, there were 220 days of load shedding. Every single day of this year, there has been load shedding. Now, it's not just unpleasant to work in the dark, not be able to cook your meals. The economic impact on small businesses is absolutely sickening. It should fill all of us with a deep sense of nausea that people who are just trying to feed their families cannot do so because there is not power in this country. It goes so far, it's so embarrassing that one of the busiest divisions in Gauteng, the Johannesburg High Court, has to close its doors to physical court appearances because there is not enough power to supply people with access to the courts. And there is furthermore talk that for the next 2 years, we will have load shedding every single day. Now, the idea that we should be appointing the best of the best is exactly what we should be doing. It's not what's being done. What's being done is that the ANC have appointed people that suit their interests, sectarian interests, not the interests of the South African public.
The ANC appointed when was the state.
I beg your pardon, my lord?
Were those people appointed by the ANC?
Well, my lord, the ANC whispers into government's ears and says, pick these people.
But ultimately they are appointed by the state.
Yes. Yes, of course. The ANC acknowledges that it has no actual appointment powers. No piece of legislation gives it those appointment powers. It is only the state that has the actual power to appoint. And what they've done is abdicate responsibility. Instead of being the ones that are doing the appointments, they go to an ANC meeting and they say, who's on the agenda list? Let's look at the minutes. Who do you want? Which judges do you want? Which deployees do you want? Are they members of the ANC? Oh, wonderful. The minutes are replete of examples where it's celebrated that so-and-so is a high-ranking member of the ANC, and of course they'd be wonderful for this board. No mention of their qualifications, no mention of what they could do in that position, but their membership in the ANC is seen as a very good reason for appointing them. And that's that dereliction of duty by the state. President Ramaphosa admits that the ANC is corroded by corruption, although this only seems to be of concern because this has affected the party's electoral support. The fact that billions of rands have been looted, the economy has been wrecked, millions have been driven into unemployment, doesn't appear to be of concern. Barbara Hogan's testimony at the Commission illustrates the damage done to the country because of the government's adherence to the ANC's deployment policy. She describes the deployment policy as a clandestine one carried out by a handful of people who have abused their power to usurp executive authority. She says the way to pursue your career is to walk a beaten path to the Tulu House and ingratiate yourself with the party. In other words, it's not become excellent in a particular domain. Work your way up through a meritocracy and work out, how to run Eskom or Transnet. No, it's to ingratiate yourself with a political party. The Deployment Committee minutes demonstrate that the committee not only has the power to place people in positions of authority, but also to have them stripped of their position. They explicitly state the need to remove Nazir Ali, the founding CEO of SANRAL, because he's proven to be dogmatic. That shows the enormous power that the ANC has to say, we don't like this person, government must remove him. The report makes it clear that cadre deployment subverts the rule of law by ensuring that real decisions are made by the party instead of those who have the lawful authority to make them. The report states the following. The Commission has heard substantial evidence indicating that multiple appointments were made to key positions in order to facilitate state capture. Those appointments were all made by the National Executive, who, except for the President in some cases, were as members of the ANC bound to the party's deployment policy. The fact that the ministers seek to convince the committee and go through such lengths to do so implies that the true and ultimate decision-making power lies with the committee itself. The point that I made earlier is echoed by the Zondo Commission report. Government has absolved itself of responsibility to make the appointments and says, what does the ANC have to say on the matter? The party is where the real decisions are made. President Ramaphosa concedes the party is where the power resides, again quoting from the Zondo Commission. Appointments in the public service sector are governed by a number of laws and policies, most significantly the Public Service Act, which seeks to ensure that the appointment processes are fair, effective, and in line with the Constitution. If appointment decisions are not made with this governance regime, but rather made behind closed doors of the park, these checks and balances are circumvented. On this point of the closed doors, these decisions are made in secret. The idea that the party is merely expressing its free speech.
Recommendations.
Beg your pardon?
Are the decisions or the recommendations made in secret?
The recommendations are made in secret.
Yes.
The actual appointment would, of course, have to be done in public by a government. But the whispering in the ears, the recommendations are now strong recommendations because there are consequences if you don't abide by them. Those are made in secret. There's this line that, well, if the policy was declared unconstitutional, it would be infringing on the party's free speech rights. The party is not publicly saying, we think the following people would make wonderful deployees at the SCOs, and then inviting some kind of discussion or debate or deliberation, allowing the public to engage with the ideas and saying, well, we make recommendations like anyone else can. This is a very different process. This is a clandestine process. This is whispering in people's ears and behind closed doors. That's not an exercise of free speech rights. That's an exercise in coercion. The report goes on to say, furthermore, if the party does have the power to decide appointments, the concern is that the party can abuse this power to achieve ends which are not in the best interest of the country. If the party prioritizes loyalty or party membership as selection criteria, there is a risk that it will not select the best person for the job, and moreover, that deployees will serve the interests of the party even to the detriments of the country. This is not just an abstract concern, this is an actual concern that all of us are living through. The best were not picked. Those that ingratiated themselves with the ANC have prospered. The rest of us have not. Now, the learned authors of the Constitutional Law of South Africa state the following about the rule of law and the separation of powers.
Okay, Mr. Oppenheimer, I really very much here for this. We have read you this.
Yes.
Yes, so I think he's just...
I won't read verbatim, but I'll go into I'll read the relevant extracts, my lord. The idea behind the separation of powers is that you cannot have all power concentrated in one body. The idea that you can have a benign dictator who will be able to, rule with wisdom and justice just isn't borne out through historical evidence. And so it's important that you separate out these powers. Now, what we have is the ANC removing this separation between the party and the state, that instead of you having a proper process where there's a delegation of power and a delegation of authority, you have the party usurping that power. The rule of law, in essence, means the absence of arbitrary power. It encompasses the view that no person in authority enjoys wide, unlimited discretionary or arbitrary powers, and the fundamental notion of equality before the law, which means that every person, whatever their station is in life, is subject to the ordinary law and jurisdiction of the courts. The ANC has granted itself powers that it does not have. It has destroyed this distinction between party and the state. Like Orwell's pigs in Animal Farm, they have proclaimed themselves more equal than others. They have upended the rule of law for their own benefits and to the detriment of the nation. Now, I mentioned earlier this value of non-racialism, which is entrenched in Section 1 of the Constitution, and we see how it has been abandoned by the ANC in their policy document and in their minutes. The minutes are replete with references to the race of the candidates. Often, when particular members are brought up for consideration or recommendation, it is their race overall that is mentioned. There's something...
passage saying that recommendations were made, race played a role. Because even when you look at the papers of the applicants, they don't mention that the ANC, this policy should be declared unconstitutional because ANC takes decisions based on race.
Oh, my lord, the PSA itself makes reference to equality and the fundamental values of the Constitution in Section 11. Non-racialism is one of those entrenched values. Non-racialism is this idea that we judge each other based on the content of our characters, not the color of our skin. And if we look through what is done in the minutes, we can see that time and time again what is mentioned is the race of the candidates, that the color of their skin matters more than their abilities, than the content of their character, their ability to do the job, to serve the nation.
the text can directly to the minutes where
My lord,
they
at
say that
page,
the people should be appointed.
at section 2, 386, there is an example of this. So, for example, at paragraph 5, the GCIS Director General, Comrade Jackson Timber presented the 27 applicants for the position. From the 27, 6 were shortlisted, 2 were female and 4 were men. All were African, and with the exception of one male who was Indian. Third candidate was female with the deployment from India agreed on. It then goes on to list, there were, for ICASA, there were 75 applicants for the permission. 10 names were presented, which only 3 were females. In the road traffic, it says the posted 50 applicants, presented 5, including 3 male and 2 female, 1 Indian, 1 male was Indian, all the other applicants were African. So there's this emphasis on race to say, this is what matters. And that runs contrary to our constitutional values of non-racialism. Now, the policy itself, this is at clause 4 of the policy, refers to deracializing the public sector. Now, there's an ambiguity what's meant by the term deracializing. One is a constitutional interpretation, which is that race will no longer play a role in determining whether or not you will be appointed. That would be a constitutional interpretation. But that's not what we see. It appears to be the case that it's about eradicating certain races from the sector. And so that has the more pernicious interpretation, appears to be what's done, which is that those who were here before, who were not in the new favored racial group, will be removed. That if you're in a minority racial group, if you're classified by the state as white or Indian or colored, well, then you'll be deracialized from the public civil service, that you don't have a place here. Now that flies in the face of this value of non-racialism. To give some more historical significance to this value of non-racialism, we can look at something like the Freedom Charter, which proclaims the following. South Africa belongs to all who live in it, black and white. The rights of the people shall be the same, regardless of race. All national groups shall have equal rights. All shall be equal before the law, and all laws which discriminate on the grounds of race shall be repealed. The ANC itself in 1991 produced a document called Constitutional Principles for a Democratic South Africa, proclaimed that a non-racial South Africa means a South Africa in which all the artificial barriers and assumptions which kept people apart and maintained domination are removed. In its negative sense, non-racial means the elimination of all color bars. In positive terms, it means the affirmation of equal rights for all. Our case law is also replete with examples of this idea that non-racialism is a fundamental value. Judge Sachs, in the Van Heerden matter, says that it is important to ensure that the process of achieving equity is conducted in such a way that the baby of non-racialism is not thrown out with the bathwater of remedial action. And in the Walker case, Judge Sachs says that no members of a racial group should be made to feel that they do not deserve equal concern, respect, and consideration, and the law is likely to be used against them more harshly than others belonging to other racial groups. In the Barnard case, Judge Cameron stated that we want to achieve the magnificent breadth of our Constitution's promise of equality and freedom from disadvantage. We must foresee a time when we can look beyond race. Now, the Deployment Committee's obsession with the race of potential candidates undermines this value of non-racialism and cannot be countenanced. With regards to unfair discrimination, as I mentioned earlier, Section 11 of the PSA makes explicit reference to the democratic values and principles enshrined in the Constitution and references equality. in the making of appointments and the filing of posts in the public service, due regard shall be had to equality. Now, to understand what's meant by equality, we can have a look at Section 9 of the Constitution, which gives us an indication of under what circumstances people must be treated equally. As I stated earlier, if we look through the minutes, what is celebrated is not merit. It's whether the person is a member of the ANC. For example, deciding who should be appointed to the Nuclear Energy Board, much delight is taken in the fact that the chair is a long-standing member of the ANC, and all of the members are from the ANC. Candidates who are not members of the ANC have no chance of securing the recommendation of the Appointment Committee, and this means they're engaged in an unfair and unequal competition. This is from the report. The benefit to the ANC of the committee is that the ANC individuals who get appointed will feel grateful to the party for giving them such jobs. They may strengthen their loyalty to the party and make them beholden to the party. This is highly undesirable because such an official should put the interests of the people of South Africa first, and there should be no risk that he or she may put the interests of the party above those of the country or the people. Now, what the Constitution says that the state cannot discriminate and individuals cannot discriminate, so it binds the ANC on the grounds of race, on the grounds of belief, on the grounds of conscience. What we see here is that if you're a member of the ANC, if you believe that the ANC is the true party of liberation and you want to support them, well then you can be considered. If you don't believe that, if your conscience says, I cannot accept the values of the ANC, I support a different political party, or you're of a different race that's not favored, well then you will be discriminated against. Now, the ANC itself in 2001 saw some of the dangers of its cadre employment policy, and the report quotes from the ANC's Eye of the Needle. It says, because leadership and structures of the ANC affords opportunities to assume positions of authority in government, some individuals then compete for the ANC leadership positions in order to get into government. Many such members view positions in government as a source of material riches for themselves. Thus, resources, prestige, and authority of government positions become the driving force in competition for leadership positions in the ANC. Government positions also go hand in hand with the possibility to issue contracts to commercial companies. Some of these companies identify ANC members if they can promote in ANC structures and into government, so they can get contracts by hook or by crook. Positions in government also mean the possibility to appoint individuals in all kinds of capacities. As such, members make promises to friends that once elected and ensconced in government, they would return the favor. Cliques and factions then emerge in the movement around personal loyalties driven by corrupt intentions, members becoming voting fodder to serve individuals' self-interest. Therein lies the rub. The ANC itself acknowledges that when people are placed into positions of power, when it whispers in government's ear and says, appoint these people, not doing so for pure motives, saying, well, you help me out here, I'll help you out here. Oh, you're going to be able to issue contracts? Well, these are my friends who would benefit from it. And that means that instead of picking the best and the brightest, you're picking people that are loyal to the movement. And that's why we have the economic crisis that we have. That's why you have substandard coal being put into Eskom power plants. That's why we can't keep the lights on. That's why the economy is in shambles. Now, I mentioned that one of the factors for the unfair discrimination is this idea of indirect racial discrimination. The Constitution doesn't just prohibit direct racial discrimination or for discrimination on either listed grounds, but indirect as well. And in the case of Leonard Dingler, the court held that indirect race discrimination occurs when criteria, conditions, or policies are applied which appear to be neutral, but which adversely affect a disproportionate number of a certain race group in circumstances that are not justifiable. As with direct discrimination, intentional motive is irrelevant. In the Walker case, the Constitutional Court held that conduct which differentiates between the treatment of residents of townships which are historically black areas and those residents which are overwhelmingly black and residents in municipalities that were historically white areas and whose residents still overwhelmingly white constituted indirect discrimination on the grounds of race. Now, the point of that is to say you can have a policy which doesn't mention race, but which implicitly has this disparate impact. So those who support parties other than the ANC are unlikely to be appointed by the Deployment Committee of Government. Deciding which political party to become a member of is intimately tied to one's conscience and beliefs. Therefore, the party discriminates on those grounds. With regards to race, historically the ANC was a multiracial party. It had members from all different racial groups. However, it has become abundantly clear that those categorized as white, or Indian, or colored have been sidelined within the organization. If we look at the...
Let's see now consists of only blacks.
Well, my lord, if we look at the NEC, the top 7...
I'm not talking about the NEC, I'm talking about the ANC. That is what you just read.
The NEC, well, the National Executive Committee of the ANC. In other words, there's 87 people, there's the top 7, and there's 80 others. Of the top 7, all would be categorized as black. In the 80, there is Tina Jamat Peterson, who would be considered...
The question I raised is in the state of what you just read out to us. The ANC was the multiracial political party, members from all racial groups. However, it is now clear that those categorized as white have been sidelined within the organization.
Yes, within the organization of the ANC.
But I want, well, the key that I'm seeking to know, are you saying in the organization or with the ANC, it's only blacks?
No, I'm going to give the exact breakdown. It's almost entirely that way. In the top 7, there are no white people, there are no Indian people, and there are no colored people. In the bottom 80, there is one white person, being Barbara Creasy, and there's Tina Jamat Peterson, who would be classified as colored. Of the other 78, all are black.
Okay.
So in other words, it doesn't have to be the case that they have such a rule, which is that we're a party only for people of a certain race. It just is the case that people who do not share a certain racial group have been sidelined within the party. And it's not just white people, as I point out. People that are classified as Indian or people that are classified as colored have also been sidelined. And so if the party is saying one of the things that matters for deployment by government is that you have ANC membership, and if it is the case that the ANC has conducted itself in such a manner that it sidelined people of certain racial groups, well, then there's indirect racial discrimination. Finally, the cadre deployment policy explicitly seeks to take control over the media. This is in paragraph 11 of the cadre deployment policy. And Mr. Mantashe proudly told the Commission that the ANC fostered a relationship with the Gupta family to create ANN7 and the New Age to disseminate information that was favorable to the ANC. He goes into some detail about how this relationship was formed and why they thought it was important to have their own newspaper that would push forward a pro-ANC agenda. Now, the media is often described as that fourth branch of government, that it has this obligation to hold the powerful to account, that it should be truly independent, that it shouldn't have party hacks inside of its ranks, that it is free to be able to report on the misdeeds of a political party and the misdeeds of government. In Kolomisa, the court held that the success of our constitutional venture depends upon robust criticism of the exercise of power. This requires alert and critical citizens, but strong independent newspapers, journals, and broadcast media are needed also. If those criticisms are to be effectively voiced and they are to be informed with the factual content and critical perspectives that investigative journalism may provide. Now, the New Age and ANN7 are far cries from independent press. They're set up by the ANC in line with the infamous Gupta family to push an ANC agenda and mislead the public. In the Kamala case, the Constitutional Court held that in a democratic society, the mass media play a role of undeniable importance. They bear an obligation to provide citizens with information, which is critical to the development of a democratic culture. If citizens want to deliberate about what's going on, they need to have access to accurate information, not propaganda. As primary agents of the dissemination of information and ideas, they are inevitably extremely powerful institutions in a democracy, and they have a constitutional duty to act with vigor, courage, integrity, and responsibility. The manner in which the media carry out their constitutional mandate will have a significant impact on the development of our democratic society. If the media are scrupulous and reliable in the performance of their constitutional obligations, they will invigorate and strengthen our fledgling democracy. If they vacillate in the performance of their duties, the constitutional goals will be imperiled. This line of cases recognizes the importance of an independent press, and the report shows that the ANC tried to undermine this idea of an independent press by setting up its own parallel structures. And the policy itself says this is our goal. When you are looking at all the levels of state power to control, we're not just satisfied with the state. We want the media too. We want business. We want sports. We want culture. In conclusion, it makes it much easier to engage in state capture if the watchful eye of the media has been blinded. It's part of the tactic is to say, how do we hide our sins while we erode the freedom of the press? We have our own parallel structures, and the citizens won't know what we've actually been up to. Both government and the ANC have shown themselves to be complicit in subverting the fundamental tenets of the Constitution, and it's vital that this honourable court shows its disdain for the actions of the respondents by granting relief sought by the applicant. Now, there's been some discussion about which sections of the policy could be looked at. There's an argument that the policy as a whole implies what the ANC's agenda is. However, I think the specific emphasis could be had on sections 8 to 12, which set out how the deployments must happen, which areas must be captured. Those are the sections of the policy that strike me as the most pernicious. They're the driving engine. I think my learned friend, Mr. Katz, is right to say that the policy is the root problem. Justice Bum described it as the root evil. That the policy is what enables the human action. The policy on its own can be determined to be unconstitutional. The human action stems from the policy. The human action where individual members of the ANC will sit, will have their committee meetings, will then recommend to government who ought to be deployed, and if those recommendations are ignored, well, then there'll be consequences. That human action is obviously a problem, but it stems from the policy itself. The policy itself can be understood on its own terms, that a clear reading of the policy shows that it's unconstitutional and unlawful. And of course, the evidence at the Zondo Commission amplifies this. It gives examples of how it is actually done, and that can be used to supplement the case. I have no further submissions.
Thank you, Mr. Oppenheimer. I see your case is that your client supports the relief sought by the applicant. In other words, that the policy is unconstitutional. And I see mostly you rely on discrimination and you emphasize race. There is a complaint, and you'll tell me whether this complaint is valid, that when you are challenging a constitutional, when you are raising a constitutional challenge, you are not entitled to go directly to the Constitution, but to a legislation, to a subsidiary legislation. First, you must tell me whether that's a valid constitutional complaint. And secondly, whether is there any reason why the challenge is not directed in terms of enabling legislation, but it's going directly to a constitution?
Yes, Justice. The principle of subsidiarity is the correct principle. You can't rely directly on the Constitution, but you're not obliged to go the route of Papuda. As I mentioned earlier, Section 11 of the PSA is that subsidiary legislation that's giving effect to the non-discrimination clause and the equality clause in the Constitution. 11.1 says, in the making of appointments and the filling of posts in the public service, due regard shall be had to equality and the other democratic values and principles enshrined in the Constitution. So itself says that if you want, when you're determining who should be appointed, you have to take into account the constitutional value of equality, which means that what it does is it imports Section 9 of the Constitution in. So if you want to find what are those obligations, you can look at the Constitution itself. But it's this legislation which provides that power. So it's not a direct reliance on Section 9 of the Constitution, it's indirect reliance because it's incorporated. Now, the other democratic values imply non-racialism. That's in Section 1 of the Constitution. It also implies equality before the law. So those are the sections that can be relied upon to make the claim that the policy itself is unlawful and that it breaches Section 11.1 of the PSA. And by implication is unconstitutional because the legislation makes a reference to the Constitution and the Equality Clause. So there's no need to run an equality court case using PAPUDA. This legislation is sufficient on that grounds and meets the subsidiarity requirement.
Okay, thank you.
Thank you very much. She's talking cost. Well, we're going to